leaving Lisa Kaufman.
Is this mic on? Yeah? Okay, we are going to get started. I know there's still some people in the hallway, but I think if we start going, they'll come in and be sorry that they missed anything at all. So it's my very happy task to welcome you all to Northeastern University School of Law today. My name is Martha Davis, and I'm the Associate Dean for Clinical and Experiential Education here at Northeastern. You'll see on your program that we were hoping that President Joseph Aoun would be able to join us this morning. Unfortunately, something came up at the last minute. He won't be able to join us, but he sends his regrets and wishes that he was here to welcome you himself. I want to say a few words about the law school and the program on human rights in the global economy, which is sponsoring this event, before we go forward into the substance. As many of you know, Northeastern Law School has the largest cooperative learning program of any law school in the nation. Our students and our professors are deeply engaged in learning and teaching law, but also deeply engaged in using the law to further social justice. Our deep ties to the community are re-cemented each academic quarter as 200 students move out into the field to do rotations in real-world settings, many of them with public interest organizations, many of them with organizations dealing with immigrations and immigrant communities. And then they return for the next quarter at the law school, and we make 800 such placements a year. We're happy to use these deep community ties to develop programs like the Institute today, which bring together activists and scholars and push both to think beyond the boundaries of the current legal framework to imagine what the law could be and how we might get there. The program today takes place under the auspices of the law school's program on human rights and the global economy, or we call it FERGI. And our executive director, Jillian McNaughton, was out in the hallway. I'm not sure she's in here yet, right here. And she's a human rights scholar and activist in her own right. FERGI was founded in 2005 by founding director Hope Lewis, and it's developed a special role as a center for scholarship, discussion, and advocacy on economic, social, and cultural rights that distinguishes it from many other law school human rights programs that focus more on civil and political rights. Today's program, let me say we sponsor fellowships with human rights organizations. We publish a journal. We develop programming like the program today. And today's program exemplifies the work that we can undertake here at Northeastern Law School, where our committed faculty are able to take the pulse of the public debate and are willing to step up and do more than write articles about it, even though that's important too. We do that too. So we're happy to be able to bring people together for these kinds of public discussions combined with working sessions with the goal today of developing a set of principles, today and tomorrow, a set of principles, the Boston principles, that will have a real-world impact on the issues that we care about. There will be time for many thank yous during the course of the 2 days, and there are many people to thank. I'm not going to start down that road now, but I thought that I should at least I want to acknowledge the leadership of Professors Hope Lewis and Rachel Rosenblum, the co-chairs of the Institute, who planned this event. And they recognize the need for a conversation about immigrant communities that gets us beyond security to examine the economic, social, and cultural rights of those individuals and communities. And so I want to recognize them for that vision. Now I'm going to turn the floor over to Professor Margaret Burnham, who's the director of, on the next page, Northeastern Civil Rights and Restorative Justice Project, who's going to introduce the roundtable discussion that'll set the stage for today. Thanks, Margaret.
You, Margaret. Thanks very much. Thanks, Martha. And I'm going to ask you to keep your hands poised for another moment, because I really do think we need to acknowledge the tremendous work that both Hope and Rachel and Jillian have done to make today possible. Not only the intellectual work, the conceptual work, but also just the junk work, the dirt work, the getting out the program, the making the return phone calls to people who don't get back to you for 5 or 6 days, making sure that the veggies have the right lunch and all that. That's the kind of stuff that we professors here at Northeastern University School of Law do with joy and pleasure. And so we really thank you, Rachel and Hope. Well, of course, Martha, for her tremendous leadership. As she said, this program FERGI began in 2005, and we have just grown tremendously. And it's been Martha Davis's, again, her contacts with folks in the broader world outside of our community, and her vision about what it would mean to bring to a law school a program that would focus would have a different focus on economic, social, and cultural rights. So for building that program, Martha, we thank you as well. We're sorry our president can't be here, and maybe we'll see him at some later point in the day. I think the way this program is organized is we've got this time together, and then we break down into really working sessions where we get to talk face-to-face to experts across the field, and then we come back together for social events, and then, of course, for another kind of wind-up, open panel discussion at the end of our 2 days together. So for those of you who have traveled from afar, as well as those of you, and I see many in the room, who came from downstairs or upstairs or across the river, thank you for being here. So we have really an embarrassment of riches today. These 4 folks on this panel are in the leadership of the cutting-edge questions involving immigrant rights in our country and indeed across the world. Each one of them could occupy this sort of keynote, setting the stage time completely, but unfortunately we have asked them to share, you and I, and they all know that they have 10 minutes apiece to address us, and then hopefully we'll open up into a really wonderful discussion. So I'm just going to give an introduction across the table, because you have their bios, and I want it to be a conversation among the 4 of them, and without my interruption. Mustafa Shisti will start our discussion. He is the director of the Migration Policy Institute at NYU School of Law, longtime activist and scholar and leader in this area. The Institute is a think tank that studies migration and management of migration systems all across the world, with a particular focus on U.S. immigration issues. And Mustafa is going to, as will others, address the important state and local questions that are currently on the agenda here in the United States, and in particular in the context of 287G programs. So Mr. Shisti will be followed by Ana Avendano, who is the assistant to the president and director of the Immigration and Communication Director of the Immigration and Communication Action of the AFL-CIO. And Ana has for many years been working at this very strange and, as she would put it, complicated crossroads between labor and immigration, in which obviously the labor movement was itself started by immigrants, but for many years, and built by immigrants, but for many years labor was hostile to questions of immigrant rights, until most recently, and in part on account of the wonderful work of people and leadership of people like Ana, who works closely with labor leaders all across the union leaders all across the country on matters that impact immigrant rights. Ana will be followed by one of our very own. Maria Elena Hincape is a 1996 graduate of this law school, although this room didn't exist when you were here. She was, at that point, she was probably in the dungeons of our other buildings. Maria Elena is the executive director of the National Immigration Law Center in Los Angeles. She and a number of other organizations filed this wonderful class action lawsuit against Arizona to enjoin the enforcement of SB 1070, and she has worked on enforcement issues and on questions of economic security, and has built on the really fabulous education she got right here at Northeastern. She is She is, Maria Elena is the youngest of 10 children. I love this line in her resume. Youngest of 10 children and an immigrant from Medellin, Colombia. So as I said, it is an embarrassment of riches. Let me stop talking, and we will proceed in this direction from Mustafa down the line.
You want me to go there or what?
Whatever's convenient for you. If you prefer to be up here, that'd be great, I think.
Thank you so much, Martha, and thank you so much for the organizers of this conference, especially Rachel and Hope, who I do want to congratulate at least on one thing, of trying to have a conference on something which is not comprehensive immigration reform. Because if anything we have learned in this field is that we have paid too much attention to the progress and the demise many times of comprehensive immigration reform, and not paid enough attention to other important things that are happening in the world of immigration and in the lives of immigrants. I think one of the most significant developments, and I think not particularly well appreciated either by advocates or even by legal scholars, is the increasingly important interplay between immigration enforcement and our criminal justice system. I think the most important access to this, why it has become I think important in recent times, is the increasing devolution of immigration enforcement authority from the federal to the state and the local levels. I think many of us know that before 1996, for about 100 years of our country's history, immigration was considered an almost exclusive federal domain. In fact, it was considered almost akin to foreign policy. We don't allow Sheriff Arpaio to have its own foreign policy. We should not allow to have its own immigration policy. The county of Barnstable here is not allowed to have foreign policy, should not be allowed to have its immigration policy. But something changed in 1996 in the form of the legislation that was enacted, and unfortunately both Wade and I cut our teeth in that, have scars to show it, and in many important meetings of the White House, cut some of the important deals which we have now begun to pay price for. Wade especially needs recognition for that. He not only organized many of those meetings, he presided most of those meetings at the White House. So we now, it's important that we reflect on what we did in 1996.
You're shifting blame, Lucy.
Apportioning it, if nothing else. So beginning in 1996, as you know, we saw increasing devolution of immigration, and increased more after 9/11. Both in terms of Congress giving authority to states and localities, but also the rise in immigration activism at the state and the local levels. And you've all known about SB 1070, which we'll hear a lot about, and Umar Jadwat, who from the ACLU, who argued that case in Arizona, is here, and I'm sure he'll say more about it. And we all heard about Sheriff Arpaio's attempts to crack down on unauthorized immigrants. They have captured the imagination of the country. But a lot of other things that are happening are actually potentially more important, because I think at the end of the day there's good reason to believe that SB 1070 with good lawyering will be struck down. But important measures where Immigration and Customs Enforcement, called ICE, has partnered with local enforcement agencies is some of the most important things that is happening in the interplay of immigration enforcement and local communities. I think many of you would be surprised to know that today there are about 14 separate programs that ICE has with local law enforcement agencies for partnering on immigration enforcement at the local level. And it's a rubric of programs, and I never remember the name unless I read it. It's called the Agreements of Cooperation in Communities to Enhance Safety and Security, popularly called ACCESS. And if it's a mouthful, don't worry about it. No one even at ICE knows what it stands for. And of these 14 programs, I'll today talk only about two, which is Section 287G program and secure communities, and also talk about them very quickly. Parenthetically, I must say that of all these 14 programs, a program called CAP, Criminal Alien Program, even though we won't talk about it today, does produce half of the total inmates in immigration prisons every month in our country in the last few years. So sort of true to cable news, I won't talk about the most important thing. I'll talk about the things that have attracted the most attention, which is 287G and secure communities. First about 287G. I mean, how did 287G become a household name, at least an immigrant household name. It was given birth to in 1996 by Congress by adding a section to Section 227 of the Immigration Nationality Act, which allows local authorities to sign contracts with ICE to enforce certain aspects of immigration law. Though it was born in 1996, it almost had stillbirth till 2001. Not a single agreement was signed in 2001. The history and the evolution of this agreement itself is very important because it has evolved in a recent paper. That's why we titled it and a program in flux. No agreement was signed till 2001. In 2001, for the first time, the state of Florida signed its first agreement, which allowed them to track local pilot schools so that the terrorists who had taken training in that area would be tracked for national security reasons. From 2001 to 2007, only 8 agreements were signed. And these were highly narrow agreements with very specific targets of going after special interests of criminals with national security component. In 2007, there was a huge spike in these agreements. 26 were signed in 2007, 28 were signed in 2008. And not only did the numbers increase, but the nature of these agreements increased. They stopped becoming narrow-focused or targeted criminals, but started becoming sort of the catch-all ways of catching and removing as many undocumented immigrants as possible. So by May of 2009, there were like 66 agreements in place. And the Obama administration had taken over. There was speculation and expectation that these agreements will be terminated. And in one of the largest sign-on letters that I have seen, 521 organizations around the country, including many law enforcement agencies, asked the president to terminate the program. In July of 2009, Department of Homeland Security not only did not terminate the program, they signed 11 more agreements, sending the signal that this administration was going to continue the program. In announcing that move, they also said that they would be renegotiating these memorandum agreements. So today, there are about 71 active agreements. And we at the Migration Policy Institute thought that it has now reached that stage. It will be good to assess the effectiveness and the costs of these programs. There are 3 kinds of, since there are a number of students here to make it clear, there are 3 kinds of 287G agreements. There are task force models where local police can go and in their field visits, they can actually arrest some people for having violated immigration law and bring them into the prisons. Second are jail models where you only check the immigration status of people after they are taken into the jail. And the third are hybrids, which are the combination of the two. 40% of them are jail models, 40% task force models, and the 20% are hybrids. The argument for the 287G is very simple, that this expands the federal government's power to go after undocumented immigrants, especially who have committed crimes. And on the other hand, it allows local enforcement agencies to respond directly to the concerns about illegal immigration in their communities. The critics of the program have always said that these programs undermine the trust with immigrant communities and therefore increase sort of the public safety. It also leads to arrests and minor infractions, and it results in racial profiling. 2 studies, one by the GAO and one by the Office of Inspector General, also have criticized the program, mostly for lack of federal oversight and for failing to articulate what the real purposes of the priorities of these programs are. I think partly in response to this criticism, Obama administration last year said that they were making a reform of this program. At the heart of the reform, we don't have too much time to go, I'll be glad to do a question and answer. At the heart of the program is a new memorandum agreement which they asked all jurisdictions who had the old agreement and all new ones to sign. And there are a lot of changes in the agreement, but the 2 most important provisions of this are that it, for the first time, establishes a set of enforcement priorities. It says local, so that you must go after certain kinds of criminals of high interest, people who have committed sort of serious criminal crimes which have a public safety component to them. And it also increases the federal control over the operations of these programs, especially the task force program. So on paper, you could actually say that by prioritizing and going after serious criminals, we have come full circle in this program and gone back to the time when it was targeting only serious people of special interest. And by having greater supervision of the program, the government may be responding to the criticism of the immigrant advocates. Whether this program, the new agreement has any meaningful impact, obviously depends on how they're being implemented. That's why we at MPI this summer did a study, beginning in spring into the summer, of 7 jurisdictions where these agreements are in place, and we are in the process of writing reports. I can't share too much about what our recommendations or conclusions are going to be, but I'll say only 2 things here. A is that it's quite clear that this is an uneven program, that the outcomes of this program vary tremendously from place to place, which casts doubts on the national priority of this program. Secondly, the new agreement that this administration pushed forward has had very little difference on how these localities are operating. Indeed, the only place where it had any significant difference was in Los Angeles. It was one jurisdiction which negotiated this new agreement for about 8 to 9 months and wanted to make a real argument with the federal government. I think many of you may not know, 2 days ago only, the Board of Supervisors in Los Angeles voted by 5-0 margin to go ahead and extend the program. Our fearless leader, Marilena, the leader of the immigrant community in Los Angeles, I'm sure, will explain to us as to how the 5-0 vote in the most immigrant-friendly city in the country happened. So wait for the report of ours will be out in about 6 to 8 weeks. Very quickly on secure communities. It's the most recent of these programs. It was announced in March of 2008, launched in October of 2008 in Texas. And it basically asks everyone who is brought into a jail where this program is installed to give their fingerprints and the biometric information. That is matched against Department of Homeland Security's FBI and immigrant databases. So it's the most instantaneous check of the criminal and the immigration history of any inmate who is brought to the jail where the program exists. It instantly signals to ICE whether someone is in violation of the immigration law or is removable, and it sends that signal to the local jail where that person is in custody. And a detainer can be placed on that person. So it has had an obviously huge, rapid growth. It was started only 2 years ago, and today there are 695 jurisdictions in the country in 32 states where secure communities is in operation. By 2013, all the state and local jails in the country are expected to have the secure communities in play. Now, the goals of the program, according to ICE, are very simple. They want to target high level of them. They have actually now categorized level 1, level 2, and level 3, depending on the seriousness of the crime. And they have said that they are interested in removing only people of level 1 and level 2. Now, that's the defense of the program. And they also say, since this target is serious criminals, and since they fingerprint everyone who's brought to the jail, it is a protection against racial profiling, because you don't discriminate against people when they're brought into the jail. Now, the criticism of the program is equally simple, that there may be no racial profiling about people that you fingerprint, but how people get to the jail may be a product of profiling on the streets. Second, there are no regulations on this system. There are no memorandum of agreement except the ones that are signed with the state governor's office typically, and then they cover the entire localities in that particular state. And most important, which has got a lot of attention, till recently we thought this was a voluntary program, that actually people can choose to be included in the secure communities. In 2 recent interviews by Secretary Napolitano and ICE Assistant Secretary Morton, it's become increasingly clear there is no way of opting out of a program. if the governor of the state has signed the program, every detention facility that wants access to this database is automatically tied to secure communities. And obviously, I think from my point of view, the major criticism of the program so far is lack of transparency. So we have no idea how many truly level 1 people are picked up and removed as a result of this program. So transparency and accountability is a serious issue with secure communities, especially for a program that has scaled itself so high. Let me just conclude, only because of the relevance of this conference, is that how do the issues of rights come into play with the devolution of immigration authority at the state and local levels? I still believe that the rights framework is the right way of approaching this subject, because even when you support an immigration enforcement regime, an enforcement immigration regime will only be credible and acceptable if it has a rights protection attached to it. Now, all these things, all the devolution in the context of 287G of secure communities, raise fundamental, bedrock constitutional principles issues of due process and equal protection in the context of who's picked up in the street and whether they're subject to racial profiling. It invokes extremely important issues of both social and economic rights. I mean, of the interviews that I did around the country this summer, the ones that I was touched by most in the communities were kids saying that they're scared to go to the school because they don't know what will happen to their mom on their way being driven there because she could be caught at a traffic stop and her driver's license could be checked. Of women who have to make choices whether they can attend a domestic violence clinic just because they could be caught on the way to the class. And people are making difficult choices about when to drive and when not to drive, and strategically using it only when it's most needed to go to buy emergency medication for your kid and not to go for things where you have the discretion. Or asking their minor kids to drive when they know they don't have a license because the minor kid may be a U.S. citizen. Or actually being caught, brought in for a crime and not even being convicted for the crime and then be removed. Now, what kind of compromise that's doing to our criminal justice system is, I think, extremely important and raises highly important sort of issues of rights that this conference is going to talk about. Thank you so much.
Hi, good morning.
Good morning.
So I have a confession to make. I prepared 3 different sets of talks for today because I really wasn't sure about what the audience was for this panel. So I'm curious, how many of you are students? And practitioners? Professors? And how many of you focus on international? I know Sarah does. The rest are just domestic. So anyway, after listening to Moose, I decided I have a mixture of my 3 different sets of talking points. So if I don't make sense along the way, please forgive me. I'm going to talk to you about the issue of worker rights, particularly focused on migrant worker rights. I'm not going to focus just on the situation of U.S. immigrant workers, because really the situation of U.S. immigrant workers is in many ways no different from the situation of migrant workers around the world. What we've seen over the past 3 decades is that multinational corporations have been taking a greater and greater role in global governance, really blurring the line between what is governmental action, what is the action of a nation state, and what is a corporate policy. And as a result of this trend, workers around the world have lost power. The attack on freedom of association, not surprisingly, has been at the center of this global agenda, at this global economic agenda. And throughout the world, but particularly in the United States, this attack has taken the form of both a multi-billion-dollar industry that has been set up for the sole purpose of busting unions in the U.S., but also the global manipulation of legal structures and regulatory regimes that are denying workers the right to exercise their rights, whether those rights are individual rights or collective rights. And I'm going to talk about that dichotomy in a second. Immigrant workers or migrant workers actually are really bearing the brunt of this new global economic regime. In the United States, this new global regime has had a devastating impact on the low-wage labor market. Again, you can't look at the low-wage labor market with ignoring immigrant workers, because immigrants in the U.S. Low-wage labor market are disproportionately represented, and it's a labor market that is growing and one that is completely out of control. A recent study conducted by academics from UCLA, from NYU, or the Brennan Center, and Nick Theodore of the University of Illinois at Chicago conducted a survey of low-wage labor markets in Chicago, Los Angeles, and New York. And it's really the first survey of its kind to really look at both the demographics of this labor market and the labor practices in these labor markets. And what they found was systemic violations, that it wasn't just a few bad apple employers, and it wasn't just one particular sector. 1 in 4 workers in these labor markets in these 3 cities were paid below the minimum wage in a given work week. Fully 76% of those who worked overtime were not paid the required time and a half. More than 2/3 did not get the meal breaks they were entitled to, and of those who came in early or stayed late, 70% did not get any pay at all for the work that they performed outside their regular shift. This is the impact and the impact on the workers themselves is that as a result of these unlawful practices, the average worker lost $51 a week, $2,600 a year for a full-time worker. And the estimate is that the 1.1 million workers across the 3 cities in these labor markets were robbed of $56.5 million every week because of employment and labor law violations. So this is the heart and center of the new global economic agenda. And undocumented immigration is a condition of existence for this new sweatshop model, both in the United States and globally. So the question is then, what do we do about this? And this is when the question of different strategies or how do we look at workers' rights? The issue of whether workers' rights are human rights is actually not without controversy. Lance Compa in 2000, Human Rights Watch, Lance Compa authored the report, wrote a report called Unfair Advantage, which was a critical examination of U.S. labor law in the context of international human rights standards, but seen as advancing a new and important mode of analyzing labor laws through the lens or the frames of human rights, of the human rights frame. And that report wasn't received in all quarters with open arms, which is surprising in some ways, but it's not in others. Within the world of labor, within the world of collective rights, the issue of human rights enforcement or enforcement through the human rights lessons is sometimes problematic because it's seen as a basis because they see as workers that the frame actually, I'm quoting for an academic, but that the individual is entitled, that the frame focuses on what the individual is entitled to, rather what is in the interest of the community, solidarity, or civic virtue. And Nelson Lichtenstein, a labor historian who is one of the scholars who's very critical of the human rights lens, has summarized basically the concerns of looking at worker rights as human rights through basically four different areas. That this lens can often mean ineffective legal enforcement, remove from the shop floor concerns of workers, can create a dependency on legal and technical experts, and incapacity to deal with broad structural and economic crises, and a failure to challenge or even temper managerial prerogatives and authorities in the workplace. Now, this is a much longer discussion that really brings in issues of class, and we can spend an entire day actually just talking about whether worker rights are indeed human rights and whether we should be using one or the other lens, but that's really an academic discussion because I think at the end of the day it's a false dichotomy. And I think that, as always, it's workers on the ground who are teaching us that we don't need to actually even engage in those kinds of debates. They're academically interesting, but what's happening to workers on the ground here in the U.S. and around the world, really, at the end of the day, it really, and I don't mean to denigrate any of the academics who are focusing on this, but it doesn't really matter. Let me give you an example. Right here, with immigrant workers are actually leading a movement in the U.S. to actually show us just how much collective rights are needed to enforce individual rights. And they're doing it through a human rights model. And I'm talking about worker centers who are community-based institutions around the country that represent workers as workers, but not in the traditional trade union mode where we represent workers in the workplace. Representation happens in communities and in a variety of different ways. And these worker centers are really creating a whole new model of organizing workers, and are creating a new labor movement for what workers are calling a new labor movement for a new economy. This new labor movement isn't divorced, of course, from collective rights, and for a very good reason. And let me give you the example of a campaign that we're working on right now with car wash workers in Los Angeles, this campaign is a result of a new initiative that we started at the AFL-CIO in 2006, where we've been partnering with worker centers and their worker center networks around the country. In 2006, our governing body adopted a resolution that allows worker centers to affiliate formally. Worker centers get charters to local AFL-CIO bodies, central labor councils, which there are about 500 around the country, and state federations. These are formal affiliations, but they don't carry any governance rights, and they don't collect dues either. They really represent a commitment of the labor movement to really join with this new, growing, burgeoning labor movement for us to together actually restore the right to organize in the United States. As a result we've partnered with the National Day Labor Organizing Network, with the Interfaith Worker Justice Network, with NASE, which is a binational network, and now we're working on partnership agreements with Domestic Workers Network, with the Alliance for Guest Worker Dignity in the South, and with the Restaurant Opportunity Center. But the car wash campaign in Los Angeles was really born out of the effort to really merge these parallel labor movements. In Los Angeles, there are about 10,000, and then this is just the greater metropolitan Los Angeles area, there are about 10,000 car washes. Angelinos love their cars. There's more car washes in Southern California than in the rest of the country combined. I'm not kidding about that. And this is an industry that relies entirely on immigrant labor, mostly, if not entirely, undocumented labor. Workers in this industry that is entirely out of compliance, there are no chains in Southern California because chains can't compete, because the entire industry really operates substandard. So legal aid workers and worker centers in Los Angeles have been working for about a decade to implement the rights framework to really lift workers out of poverty. And so they had a very good system, a great clinic system where they would do worker intake of cases and litigate cases both in the courts and the administrative process, and many times they would win. But what they found year after year is that those victories were essentially hollow victories because they didn't advance workers' rights. Many of the cases settled for pennies on the dollar. Most, if not all, contained confidentiality clauses that didn't allow workers to even talk about their own victories, and really created the system of just including worker violations as the cost of doing business. The campaign then adopted the other strategy, which is very common as well, is to change the law, to pass a new state law that would require car washes to register so that there would be some sort of regulation over the industry, which doesn't exist now. And as we find so many times, that law took years to pass, and then the governor wouldn't sign it until it was diluted, and then the state wouldn't issue regulations. And so what we found is that the car wash worker law has helped organizing efforts, but it really hasn't been the answer, again, for car wash workers. So in 2007, a group of workers who really we got to know through our partnership with the Day Labor Organizing Network, because many of car wash workers cycle through day labor centers as well. The lawyers and our worker representatives came to us and said, we recognize and realize now that to really change the structure of this industry and to really bring car wash workers out of poverty, we need to figure out how to obtain some sort of collective bargaining mechanism for these workers. Now, this isn't a traditional industry. It's about 400 different work sites, which with at most about 15 to 20 workers a shift. And again, an industry that's entirely out of compliance. So the campaign strategy is really twofold. One is to bring the industry first up to standards by requiring that car wash owners sign what we're calling a clean agreement, which is an agreement just to comply with minimum standards, and to allow workers, when workers are ready, neutrality. In other words, so that not to interfere with workers' right to join a union. The idea here is that at the end of the day, the steelworkers, by the way, are the union that is the union component of this organizing campaign, but this is really a community labor campaign where the community is there as an equal partner. Many times in the past, labor community campaigns have been really about solidarity. And so when we see a partnership between a community center or a worker center and a union, it often involved, there was a rally that the union needed some community folks to go to, and of course, we will act in solidarity, so we would call people up and they would come to our rally, or we would write a letter in support of some local ordinance that the community groups needed. But this new model is really not about that. It's about bringing the best of both worlds together. And so the campaign is managed by a steering committee and a community advisory board that really consists of different members of the community, along with the unions and lawyers are always involved. But it's really changing the way that both the union culture, it's not changing the union culture. It's really been an interesting campaign to work on because it's really the coming together of two different cultures. The union organizers who are very methodical and structured and have charts and rate workers and run a campaign like a campaign, and the community organizers who for years have been putting out fires and are really that's the model which they're most comfortable with. And so combining these two methods has been really interesting, and we can talk about that another time. But what the car wash campaign really is all about is that at the end of the day, workers are going to have a system through which they can enforce their own rights. A collective bargaining mechanism that doesn't require workers to file any sort of regulatory, administrative, or legal claims, but they would just be able to use the system to really enforce their own standards. And that at the end of the day, the local union, the local steelworker union, will operate both as a traditional union that will bargain contracts and handle grievances and that sort of thing, but also as a community-based organization, a worker center that will be rooted in the Los Angeles community and will serve the functions that worker centers currently serve for the community. So it's a hybrid. Admittedly, it's not close by. This is an industry, again, that's very difficult to organize. But this is a new vision. It's a vision that was created by workers, and it's a vision that I think really represents the best of really when we talk about enforcement of individual rights or collective rights, we really are talking about the same thing. So I'm going to conclude by just a couple of thoughts. If we're going to remain committed in this country to be a mixed society that both permits economic freedom, and that's our capitalist model, but at the same time prevents the worst forms of economic exploitation, we have to understand the vital connection between unions and individual rights. And that's an uphill struggle. And it's not just an uphill struggle in the United States as we work toward changing our own immigration law, but really in the development of global policy on migration, it is not going in the direction of recognizing workers' rights as collective rights, whether they're seen through the human rights lens or not. We're really dealing with a new global regime that is looking at migration as something that is to be managed. Workers are seen as just agents of development, and the outcomes are measured by how much money workers are able to send home by remittances. And so our challenge is to really ensure, both on our national level and on a global level, that the system of rights that's built in any migration system that really recognize not just individual rights, but the rights and the ability and guarantees the ability of workers to be able to act collectively. Thank you.
Great. Thank you so much for all of you to come today. It's really a great honor to be here at my alma mater. There are so many people in the room that I am grateful for everything I've learned from, including great attorneys in the field as well. It's really important to me to see how the work that we did as students, whether in the 80s, like Nancy Kelly and John Wishlow Carrera, or myself in the mid-90s, to see how this has grown at the law school. So again, thank you all. I'm going to begin by talking about how this national security construct has resulted in innumerable attacks on the rights of immigrants, and how this country, how that has endangered our collective civil and human rights and our civil liberties. As we've seen throughout history, particularly during economic downturns, immigrants have always been scapegoated. One of the concerns at this point in time is that the economic recession that we are feeling in, it's important to recognize that there is a lot of pain in communities of all colors, of all classes. It's not just even working class communities who are in pain. The middle class is feeling the pinch as well. And it is because of that economic insecurity, as well as the anti-immigrant sentiments that are grounded in the deep roots of racism and the fear of the changing color of our nation, that are contributing to the anti-immigrant sentiment that we have today. There's a cacophony of voices calling for changes. Particularly, we hear recently changes of the 14th Amendment to deny citizenship to U.S.-born children of undocumented parents. Some of us think, bring it on. It'll be a beautiful opportunity for a colorful, broad alliance for those of us to safeguard the 14th Amendment of the Constitution. That we in the United States it's been a gift that has been given to us by African Americans and allies who fought for the 14th Amendment. And anti-immigrant sectors now are trying to take that away. Now, the 14th Amendment, any changes to that, may not actually ever happen. But what's symbolic about this is that the efforts to do so, the fact that this can even be talked about today, and it could be part of mainstream media coverage, talks about the toxicity in the climate. And it is that which is so endangering for our rights, as an identity as a nation, our individual rights, but also about the meaning of citizenship. And that's truly what's at stake in the United States at this time. This toxic climate is creating space for the violation of human rights, of civil rights, of labor rights, of rights across the spectrum. And I'm going to be focusing on three areas. One is the violation of rights with respect to access of economic supports. Secondly, access to health care and access to education. And we'll have time, I think, in the Q&A to get into some of the other topics like labor rights and the enforcement issues that Moose has raised. I'm going to start with an example from Arizona, which probably isn't a surprise given the space that Arizona is taken up. What may surprise you is I'm actually not going to talk about SB 1070. I will leave that up to my compañero Sal Reza, who is in the front lines and is really among the leaders of organizers who are showing us the way. Instead, I'm going to talk about HB 2008. How many of you have heard of HB 2008? All right. Okay, good 2 or 3 people. Sal, because he's in the trenches, program officer at Ford, probably reading our reports from NILC, and a wonderful student who knows her stuff. So HB 2008 is a pernicious law that passed in September 2009. Very, very little attention that has been paid to it. And we at the National Immigration Law Center have been working with community groups and low-income immigrants in Arizona to fight back against HB 2008. What HB 2008 does is that it requires public employees in the state of Arizona to report anyone that they have discovered is undocumented to the immigration authorities. And that is for individuals usually who are going to apply for WIC program, for Medicare, for other safety net systems for their U.S. citizen children who are actually entitled and eligible for them. But as a result of the mother going to the office to apply for their child, maybe their 4-year-old child who is a U.S. citizen, and the state employee asking very complex questions about, very simple questions about very complex immigration status, immigrant women and men have been detained under this law, have been reported to immigration and detained. Since September of last year, we have received information, and these are the only ones, the cases that we know of at this point, of about 1,500 people that have been reported to the immigration authorities, simply because they were seeking access to the safety net systems that their children and many of them were eligible for. This is not limited to Arizona, unfortunately. Arizona is definitely ground zero on the anti-immigrant fight. But we at the National Immigration Law Center are dealing with these cases in states ranging from Georgia to Utah to Nebraska, and it really is devolving across the entire country, where basic rights to housing, where children are concerned about whether they will be evicted because the landlord is now going to ask about their immigration status, or whether they're actually going to get reported to immigration because the landlord finds out that they don't have legal status. Similarly, the anti-immigrant laws that we're seeing at the state law are trying to deny all types of access to a whole range of economic supports. And in the healthcare context, we see this at the federal level as well. In the healthcare context, we saw in the very historic health bill that was passed under President Obama, which we're very, very happy about. However, we also saw how undocumented immigrants were denied access to health care even if they paid their own money to be part of the exchange. And this was a result of policymakers completely given in to the anti-immigrant sentiments in Congress, basically saying, no, undocumented immigrants will not be any part of this healthcare system, despite the fact that it makes sense from a health policy perspective, from an economic perspective, and most of all from a human rights perspective and a civil rights perspective. Fortunately, we have been able to make significant gains as part of the healthcare debate, and the actual law that passed does provide some protections for low-income immigrants, particularly those who are lawfully present. In particular, for people who are part of mixed-status families, and the definition of who is lawfully residing in the United States is broad enough to encompass a larger segment of the community that wouldn't have been included in the health reform bill. Unfortunately, parents or grandparents, adults of who are here lawfully and who've been here for less than 5 years are still being denied the access to Medicaid programs and other programs at the federal level, although they're here lawfully. We were able to reverse this for children and pregnant women under the Children's Health Insurance Program that President Obama signed into law in February of 2009, which was actually the first bill that he signed under his administration, which allowed children who had been here in the U.S. for less than 5 years to have access to much-needed Medicaid and other benefits as well. Unfortunately, as part of health reform, we weren't able to do that for the parents or for their grandparents. And again, this is a shame of policymakers who feel that the anti-immigrant voices in Congress should win out, and who, frankly, we haven't had policymakers with the backbone to stand up to those loud but small immigrant voices, anti-immigrant voices. Lastly, I'd like to talk about access to education. As we know, education is a fundamental both human right as well as a right in the United States. Access to public education is not only a right under the Human Rights Convention, but also even under our Constitution, under the Plyler v. Doe case, which the U.S. Supreme Court found that, yes, anybody, regardless of immigration status, has the right to a public education, at least at the elementary and secondary school level. Well, I have to say to you, even in places like Los Angeles, we deal every summer as parents are trying to enroll their kids into school, we constantly get calls from immigrant families, and not only Latinos. It's important to understand this affects all low-income immigrant communities. One of the major communities we've been working with in the Los Angeles County area are Korean families. And what we find is principals, superintendents, and other school actors, other state actors, who basically ask parents about the legal status, and they ask for proof of legal status in order to enroll those kids. One, sometimes they're denied enrollment, or two, sometimes they're enrolled and then actually expelled. And it is at those points that we at the National Immigration Law Center have had to intervene. Unfortunately, Arizona, and I go back to Sal, who's going to talk about Arizona in one of the smaller sessions later, Arizona's Russell Pierce has talked about introducing legislation, which we are being told by advocates on the ground in Arizona that has a strong likelihood of passing. In Arizona, they might be considering a bill to outright deny access to public education for undocumented students, and setting that up for a constitutional fight. As folks might know, Chief Justice Roberts of the U.S. Supreme Court has not been in favor. He was actually at the Department of Justice when Plyler was decided and is not on the right side of this issue. And so it is of great concern to the immigrant rights community that this issue is popping up, and it's not a surprise, actually, that it is being put out there for a constitutional fight. But in addition to access to public education at the elementary and secondary school level, there's also a denial of access to higher education for the several million undocumented immigrants that have been living in this country since they were kids, who are undocumented but consider themselves, and you would consider them when you meet them, as American as any of you who were born in this country. And these are individuals who speak English, are often among the brightest of their peers, who want to be engineers, who want to be biochemists, who want to be astronauts, who want to be teachers, who want to be principals, who want to be small business owners, and who are basically being denied the right to go to the right to access to legal status, to legalize their status, and to continue on to higher education. And it is because of that the National Immigration Law Center has prioritized the DREAM Act as one of our top legislative priorities. And we believe that the DREAM Act will change it will be a game changer in the United States when several million undocumented immigrants will be able to legalize their status eventually and continue on to higher education, which will help diminish and help basically break apart those barriers that are not basically barriers that are keeping them from being able to succeed in this country, contribute in this country, and have economic security, which we all benefit from. So in closing, I think it's important to understand that what's at stake in this country is our soul. The nation's soul is at stake, and the reason for that is that, as Moose mentioned early on, we have been talking and fighting for comprehensive immigration reform, and in fact, when we look at the comprehensive immigration reforms we've had in '86, in 1996, we are now living with the unintended consequences of those laws. And many millions of people were able to legalize their status or several million people under the '86 law. And in 1996, we got increased immigration enforcement and increased criminalization of immigrants. And it is at this point that we need to shift our tactics. We need to shift our analysis. When we have the greatest number of arrests, detention, and deportations under the most progressive administration we've ever seen, there is something wrong happening in our country. Our human rights, our civil rights and civil liberties are truly at stake. And it's important that we work together to assess what are the new paths that we should be leading towards. What kind of a country are we trying to build? What kind of society do we want? Is it a society that will be true to its fundamental values of inclusion? Is it a society in which everyone, regardless of immigration status, will be able to contribute their full participation to democracy and will be able to be a member of the democracy? Or is it a country where second citizenship is being conferred even on U.S.-born children? Is it a country where we are going to allow the hatred and racism that is currently in the news and in the mainstream? Are we going to allow ourselves to be hostage to that? Or can we really shift the debate? Can we really put in place what's needed and the strategies that are needed so that at some point in the United States we reach the point where human rights are seen as something that is part of our society here, rather than some other international concept that is not even supported in the United States by policymakers. And I look forward to engaging in the discussions over the next 2 days, because I think that the Institute has a very important place in helping us find what some of those strategies and directions may be. Thank you.
Thank you, Maria Elena, and thank you, Anna, and thank you, if I may move. So you've heard the expression needs no introduction. So I apologize. I introduced everyone else and forgot to introduce the man who needs no introduction. So Wade Henderson is the president and CEO of the Leadership Conference on Civil and Human Rights and of the Leadership Conference Education Fund. He's a long time, and when I say long time, I know what I'm talking about, because he and I started off way back when together. Leader in the movement for greater and effective civil rights, and his organization is also very much involved in how to make relevant and complementary the movements, the historic movements for broader civil and political rights in our country with the international movement for human rights. Wait a minute, Wade. Okay, I'm taking his time. I'm taking up his time. So the voice from, the outside voice from inside the Beltway, Wade Henderson.
Thank you, Margaret. That was a great introduction. I'll have to steal that, the outside voice from inside the Beltway. I'm going to use that. First of all, I'm honored to be here. This, I think, is an exceptionally important conference. I'm especially pleased to be with my very distinguished colleagues whom you've heard before me. I just want to add 2 points to Margaret's very gracious introduction. First, I also am the professor of public interest law, the Joseph Rao Professor of Public Interest Law at the University of the District of Columbia Law School. So I bring you greetings from a fellow traveler, and so I'm honored to be here in that capacity. But secondly, I just want to tell you a little bit about the Leadership Conference for 1 second. The Leadership Conference is the nation's largest, oldest, and I think most effective, I'm obviously being somewhat immodest, coalition to advance civil and human rights in our country. Our motto is that we are working to build an America that's as good as its ideals. But the more important consideration is that we are a coalition of about 200 national organizations that from time to time, when consensus can be achieved, work collectively to advance goals that we share in common. If you are not practicing coalition politics, you are not practicing the politics to win in the 21st century. No organization has sufficient strength unto itself. No community has sufficient strength unto itself to advance its broader goals unless it's working in coalition with like-minded bodies. The one possible exception to that principle is the National Rifle Association. They are very effective at what they do, and they don't necessarily need to work in coalition. Now, I do want to just highlight a couple of things, though, that really emphasize the effectiveness of the coalition approach. When you look at the last 24 months, the tenure of the Obama administration by and large, there are many who could criticize the administration as having been relatively ineffective on issues of importance to the American people. And yet that argument is belied by certain concrete achievements that would not have happened without having Obama in the White House at the same time. You had progressive majorities in both houses of Congress and an outside force to bring about change. So when you look at the legislative accomplishments, from the passage of the Lilly Ledbetter Fair Pay Act, which was the first civil rights bill signed into law by the President, overturning a Supreme Court decision in 2006, Ledbetter versus Goodyear Tire and Rubber. When you look at a hate crimes bill that extends coverage for the first time to the LGBT community, making it a bill that actually includes the LGBT population as a protected class in a civil rights bill. When you look at the bill that modified the racial disparity caused by the prosecution of cases between crack and powder cocaine, not perfect by any means, but it's reduced the disparity from 100 to 1 down to 18 to 1, and the first bill to eliminate a mandatory minimum for simple possession of crack, 5-year mandatory minimum, since 1970. And when you look at the SCHIP program, which was something that we strongly championed because of its inclusion of immigrant children, you can see the effectiveness of being on the ground. So I just wanted to give you a little sense of what the Leadership Conference is about. Now, I've divided my remarks, based in part on the presentations of my colleagues, into 3 areas. First, I want to talk about how we got here. How did we get here? And what are the sort of historic elements that helped bring about this change? Secondly, what are the political considerations today, both policy considerations and strategic political considerations between the 2 main political parties in the country that make reform so difficult? And then thirdly, what are we going to do to shape solutions to some of the problems that we've identified? I'm going to try to do that in the remaining 6 or 7 minutes that I have, so I'm going to be very brief. First, I want to, while I agree with Moose that this issue of immigration reform is obviously a national issue, has been a national issue, reserved by the Constitution to work through the Congress for the most part, and the devolution to the states is obviously a relatively new phenomenon. I want to dispel the romantic notion that somehow the immigrant tradition of the United States sort of embraces this sense of fairness and opportunity that seems to imbue the conversations that we've had so far. First, look, national security issues have always posed a significant challenge to the respect and protection of civil rights and civil liberties. I used to be an ACLU lawyer. The ACLU was founded in 1920 in part because of the Palmer raids that were directed against immigrant communities and those who were considered part of the Red Scare at the time. I need not remind anyone here about the experience of Japanese Americans during World War II who were detained. National security issues always pose a challenge to the respect and protection of civil rights and civil liberties. Secondly, this romantic notion that immigration is to be embraced as part of our national character is a little schizophrenic. I mean, because, look, the United States is a nation of immigrants, but we are afraid of foreigners. And perhaps not more so than other countries, but paradoxically more so, given the nature of how we embrace the immigrant tradition. Think about groups that are today ingrained in American society without question, and where they were in the late 19th century. The Irish, the Italian, the German. The book How the Irish Became White is a sense of the evolution of how groups in American society change their status because of the way in which they are perceived. And in fact, I'll give you another example. Senator Pat Leahy, who is the chair of the Senate Judiciary Committee, hails from both Irish and Italian ancestry. And he talks very painfully about his experiences as a child and those of his parents in seeing signs. Irish need not apply. Italians need not apply. So we come from a tradition that never fully embraced the ideals that we propose. And that has posed a significant challenge. When you look at those issues and sort of think through what that means for much of the 20th century experience with regard to immigration, while it was left largely to Congress to decide, there are clear examples that it has not always gone smoothly. Now, secondly, we have lost the bipartisan consensus that existed in the 1960s around immigration, and we have seen the pendulum shift dramatically to the right. I mean, I remind you that the 1965 Immigration Reform Act that helped eliminate the various quotas that kept the United States largely a white European country with respect to its immigration tradition at that time, paralleled the adoption of Congress of the 1964 Civil Rights Act, the 1965 Voting Rights Act. It was that struggle in part around the effort to bring civil and human rights home that helped to lay a foundation predicate for people like Senator Kennedy, God bless him, who helped move those issues in the right direction. But think about the sort of apex and then the gradual descent to the right. Because in 1980, of course, the U.S. embraced the protection of refugees through the Refugee Act of 1980, an incredible effort. There was also the Jimmy Carter Bipartisan Commission that made recommendations for immigration reform moving forward, chaired by Father Ted Hesburgh, the president of Notre Dame University, and co-chaired by Barbara Jordan, the great congresswoman from Texas, civil rights champion if ever there was one. And then the passage of the Simpson-Rodino Immigration Act that has been alluded to, 1987, 1988, a real, high point in America's response to the immigration issue. However, since that time, we have gone dramatically downhill. In part, we are paying a price, I think, as Moose has alluded to, for some of the successes we had in the late 1980s in bringing about, for example, a broad legalization program for persons who were in undocumented status at that time, lifting up the needs of children, the Plyler decision, et cetera, was a big part of that effort. But, again, there are significant problems. Now, Marilena, I thought you did a brilliant job in your presentation, and I just want to note one issue in particular, which is this right to education. We changed the name of the Leadership Conference to become the Leadership Conference on Civil and Human Rights about a year ago. And we did that because a number of the issues that we are pursuing, though they are universally recognized as human rights, are not respected as human rights within the United States or not recognized as fundamental civil rights. There is no fundamental right to quality public education in the United States. It just doesn't exist. That's what San Antonio versus Rodriguez was all about. If a state provides education, it must do so on an equal basis, but there is no fundamental requirement to provide a quality education for everyone. So, what does that mean with respect to the United States in the 21st century? These are issues that have to be challenged. All right, so that's a history, a little bit of how we got to sort of where we are. Obviously, I'll expand on that in the Q&A if you're interested. The second component is, what are the challenges today that make this such a difficult issue to resolve? Well, I contend that there are significant political interests that undercut the effort to achieve the kind of bipartisan consensus that existed on immigration back in the 1960s up through the 1980s. And in part, it's been exacerbated by the election of President Obama, whom, I value and think has made a significant contribution. But let me give you an example. The rules of the game have changed. They've changed. So what used to be sort of bipartisan pursuit of the national interest has now deteriorated into a partisan need to use whatever exists at your disposal to achieve a broader political gain. Couple that with incredible naivete and arrogance on the part of every new administration, including the Obama administration, and you got a recipe for disaster. I point out that every administration that comes to Washington always sees itself as the best and the brightest. As my grandmother would say, they're smelling themselves. And they don't take into account the fact that a lot of people have seen this before. So they all sort of come in with high-minded ideals of what they're going to assert, and they run smack dab against the political realities of the time. So Obama pursued a policy of bipartisanship that he thought was extremely important. I'll give you an example of where he was really off his rocker. He was interested in giving Judd Gregg, the senator from New Hampshire, the Commerce Department as his domain of responsibility, even though Judd Gregg had been on record voting against the continuation of the Commerce Department's Census Bureau because he felt that that was unnecessary. Census is one of the most important tools that the civil and human rights community has in the United States. It governs the distribution of over $400 billion annually. And so to put Judd Gregg in charge of the Census Bureau is the ultimate fox in charge of the henhouse. Come on, guys, it just doesn't work. And that's an example of what he's done. When you couple that with the arcane rules of the Senate that allow an individual to pursue a supposed filibuster, and in this instance, a modern-day filibuster means all a senator has to do is to raise an objection. He or she does not have to go to the floor and hold the floor as was done in the 1960s. And it allows individuals to literally block whatever legislative objective you have without due recourse for how to do it. So in the late 1970s, filibusters were almost never used. In this last congressional cycle, you've had almost 70 filibusters waged against judicial appointments and waged against substantive legislation, and it means that a comprehensive immigration bill is almost impossible to achieve when you add to that the political reality that Republicans see an advantage of blocking Obama from getting comprehensive reform because it has helped to alienate him from his Latino base, which has served his interest in advancing his election in 2008. And then lastly, this issue of race. Race comes into play in lots of different ways, guys. It comes into play in lots of different ways. There is an anxiety, a race-based anxiety about the national character of the United States and what that means in the 21st century. That flies up against the economic imperative that requires us to expand our workforce if we're going to remain competitive as we move forward in the 21st century. So demography is destiny, guys. Demography is destiny. And when you look at the workforce today, Americans, and in this instance I'm referring to largely the perception of white America, they're not producing enough babies to meet the economic challenges going forward. You're going to need an expanded workforce. And where is that workforce coming from? It's coming from black and brown, primarily, immigrants to the country who are helping expanding the base. You see that challenge in a very direct way in Europe, where Europeans are fighting against this need to incorporate guest workers, to incorporate others with traditions outside of the Christian tradition. Islamophobia, for example, is a good example of what I'm talking about. All of that is coming home to roost. So you have a serious set of problems that are based on economic realities today. Now, what are the solutions? First, I don't think you're going to see comprehensive immigration reform, quite frankly, anytime soon. I mean, I know when I say this, I bring despair to the hearts of my brothers and sisters in Washington who see themselves running around sort of helping to bring about this effort with no disrespect intended at all to my colleagues there. They're like ants on a log who keep saying, oh, just turn right, turn left, as if they are, going down the river can somehow move this effort in a way that makes sense, right? It just doesn't work that way. So you're going to have to look for incremental ways of trying to advance the broader goal. I agree with Mary Elena that the DREAM Act is a very useful vehicle for pursuing that goal. And why? Because it brings together economic interests and foreign policy interests in ways that we can't effectively address by ourselves. So, for example, the DREAM Act is supported by the Pentagon. The Pentagon wants the DREAM Act because it deals with manpower needs that the Pentagon cannot fulfill today through a voluntary army. And those manpower needs are essential when you have two front wars taking place globally. Secondly, you have the business community. The business community wants the DREAM Act because they represent the best and the brightest. Look at what Microsoft has done. Microsoft, in order to address its manpower needs, has moved across the border to Vancouver, Canada. They've built up Vancouver as if it were a Shangri-La because they can't have access to the H-1B visas that they need to fill their manpower needs going forward. And then you obviously have the interests that Marilena, Anna, and others serve in trying to get that done. And so, to us, the DREAM Act provides a very useful vehicle to bring together the interests that sometimes work at cross purposes to achieve a larger goal. And my last point really goes to Anna's issue about workers and worker rights in the future. There is clearly a need to build in an organizing effort to help protect the interests of workers. And I think the AFL is doing an excellent job in its outreach program. I commend unions like SEIU that are attempting to organize workers at colleges, food service workers like the Sodexo workers, where you have a company, global company based in France, treats its workers in France with dignity and providing them with excellent pay. But over here, they treat them like serfs. Okay, it's a disgusting display of the dichotomy in global interests between companies based in other countries that have work here. And I could go on to cite a couple of other examples very briefly. I just think that the truth is we're going to have to figure out a way of doing it. I guess this is my last point. The rights framework that Moose alluded to, that in fact all the speakers have worked to, is absolutely the right framework to pursue. It is necessary to use the rights framework as a way of pushing the U.S. to be responsive to its global economic imperatives and to its strategic imperatives with other countries. The fact that the U.S. has re-engaged with the Human Rights Council at the UN is not because the U.S. has a desire to rub shoulders with some of the worst violators of democratic principles globally. It is doing so because it recognizes that its previous posture of exceptionalism, U.S. exceptionalism, no longer serves its interests effectively. It must, in fact, engage in multilateral discussions as a way of addressing the global changes that have taken place, both regarding the economy and regarding our political status. And so, for example, we are now participating in a process called Universal Periodic Review. Universal Periodic Review is a requirement of all 192 member nations of the UN to provide a brief self-assessment of how the country perceives itself as implementing the human rights covenants to which it is a signatory. Universal Periodic Review is a very helpful device to expose U.S. Contradictions, if you will, between what we say globally and what we do at home. And so we are going to Geneva in early November, and I issued a little article here. I left a lot of things out, and I apologize for that. There's an excellent article by Risa Kaufman, who directs the Columbia University Human Rights Institute, that looked at Universal Periodic Review as a way of addressing the problems in Arizona, because Governor Brewer was so offended that Arizona was even mentioned in a report that she perceived as being critical of what the state had done, that she has risen up in complete indignation, asking that the reference be removed from the report. That's the best example I can think of the importance of moving these issues forward. And it's a direct strategic effort taken from people like W.E.B. Du Bois or Adam Clayton Powell in the 1950s, who used the U.S. posture at home and compared with what we said to countries like the unaligned nations of the UN in the 1950s to help push a change in policy. So I think there are a number of solutions to the issues that we've talked about. Many of those solutions are more incremental than global. I think comprehensive legislation is difficult to achieve, but I would recognize that Washington, inside the Beltway, plays a very important role in fashioning solutions to these issues, but these solutions can't be dictated from Washington alone. We have to have the involvement of activists like yourselves at the state and local level to help us think through how to use the power that we have together collectively to advance our collective goal. Thanks very much.
Okay, so there you have it, 4 terrific presentations, and I thank the panelists for opening the conference in such a stimulating fashion. And I open it up to you, our audience, to engage with them and specifically, everyone will have an opportunity to speak about your specific issue in the smaller work session. So I really urge you to address your remarks to the comments made by the panelists and to tell us who you are before you speak. Thank you.
Jonathan Congress, Georgia State University College of Law. This is to all This is to all panelists, but maybe perhaps most to Wade. I agree with the general premise that a human rights framework is necessary, but I think human rights language is something very different and is in many cases a deal killer. So I'm wondering how you deal with that tension. I also wonder how you deal with the tension of the noisiest opposition are the ones who actually aren't interested in dialogue, and frankly, we don't actually need their votes, but we do need, I mean, because we'll never get their votes, but we could get 67 other votes or a majority vote, but they will, without end, seek to disrupt any efforts on the part of human rights advocates.
It's a great question, and I'll invite my colleagues to respond as well. First of all, I do think that there has to be an aggressive, focused campaign that is focused on bringing the U.S. within the human rights consensus that exists worldwide. So one of the things that the Leadership Conference is pursuing currently is the Senate ratification of the Convention on the Elimination of All Forms of Discrimination Against Women, and also the Convention for the Elimination of Discrimination Against Persons with Disabilities. Why? Because those are two of the easier, more likely treaties that we can pursue for ratification. Now, that does not mean that it's going to be easily done. Quite the contrary. Getting 67 votes to ratify a treaty in the Senate is difficult now. It's going to be even more difficult in the 112th Congress after those who might have been inclined to support such ratification have lost their seats. So it is going to be a very real challenge. Having said that, this issue of using the contradiction between what we say and what we do is very important. I was in Egypt recently talking with human rights activists there who argue when the U.S. makes comments about the treatment of women in Egyptian society. I mean, how dare you? You haven't ratified the very basic instruments that would suggest you really take this issue seriously at home, much less preaching to us about what we should be doing. So I absolutely agree. I think that the economic imperative is perhaps a stronger incentive to encourage us to do the right thing than the kind of lofty sort of human rights values that are certainly necessary and important to incorporate, but are not sufficient to really move the needle. And that's why I say to you, in looking at the DREAM Act, for example, that when you have the business community on the one hand that says, look, you've got 1 million kids who we think are not only the best and the brightest, we fear that if you send them home, if you facilitate their departure, you're actually weakening the country in terms of what we need. I mean, IBM, for example, is building a high school in New York so that they will have a captured workforce. They're adding 2 additional years on the traditional K through 12 system, and with 2 additional years, if you succeed in getting through, you will have a guaranteed position with a company. That is as good an example as the need to sort of grow your talent as anything I can point to. I think that economic imperative is very, very important. So when you have the business community at the highest level, I'm talking about Google, Microsoft, IBM, I can think of many others, joining with the Pentagon and saying that we have manpower needs that are currently unmet, and that together we think the DREAM Act is an essential component in strengthening U.S. Going forward. I think that's a more compelling analysis.
I think no one can say this response is better than Wade, but I would only add one other component, is the increasing national security component to this argument. I don't know if you follow what we're doing in terms of profiling passengers at the airports. There's huge national security component. I don't know if you recently learned that there was a senior delegation of Pakistani parliamentarians who arrived at JFK, and they were taken for secondary inspection and grilled for 3 hours. Then they refused to enter the U.S. as protest, returned back to Pakistan. They were received with a rousing reception. And these are the people who are going to vote in their parliament as to whether we should strike treaties with the U.S. I think those are the kind of national security connections which are being drawn in the context of our international obligations.
Can I just add, I want to add one layer to the economic message. I think we really need to be conscious that we're now living through the deepest economic crisis that we've suffered through since the Great Depression. So the economic narrative has to change, and it has to really reflect the situation of people in the country right now. We're looking at near 10% unemployment for the next 10 years. And so the immigration dialogue really has to take into account, and we have to convince the American public that it is a good economic thing, that it will promote workers' rights, that it will improve labor standards in the U.S. to actually legalize the undocumented population, that we need an immigration system that actually addresses the economic needs of the United States, keeping in mind that the majority of the population right now is very conscious about the fact that they're living, this is the country in general. Minority communities are facing, minority youth is facing up to 50% unemployment. So, and I take some issue with this narrative that, and this isn't what Wade said or what you said, but the predominant narrative now sort of giving in to the whole national security framework that we have to be tough but fair isn't working. People don't listen to the fair part. So we really need to think about how do we talk about the issue of immigration, how do we relate to the American public about the issue of immigration, and really link it to the economic message in a way that, is much more populist that we are now. And I know that that's scary, but it's a challenge for us, I think.
I would just add a couple of things. I think your question is completely right. I particularly, for those of us that do work, and we're outside of the Beltway as well. We're headquartered in Los Angeles. But for those of us who do work in D.C., human rights language, we face this in the healthcare context, particularly on health reform. A lot of the local groups around the country were very much arguing about healthcare as a universal health, human right. And that just doesn't go anywhere at all in D.C. or even in state legislatures, right? And so, but what that says to me is the importance of messaging and framing, and the how careful we need to be about the language that we use and the narratives that are used. And I think I would just add another caution on even the economic. I agree completely that the economic narrative is an extremely important one, but we have to do so without also talking about the economic imperative as for immigrants to be seen as a commodity and for immigrant workers to be seen as production, right? And there are dangers with that. We've seen them throughout history, unfortunately. And I would just put that out there as something for all of us to think about.
Can I just add one more example, though, of that? Because I think all of my colleagues have been absolutely dead on with this. During the healthcare debate, one of the arguments that we made for the inclusion of the undocumented in the healthcare program, which, as you know, we failed. They are not currently included. So you have 13 million people outside of the existing healthcare system who, the new proposed healthcare system going into effect, that, of course, are eligible for some forms of emergency care. Clearly they're not eligible for the broad range of services, but they are. We argued that by bringing them into the system, you are better able to guarantee the fiscal health of the system, because you have 13 million people who are now precluded from buying their own insurance. We're not asking that it be given free. They're prepared to pay for their own insurance and will help make the system fiscally healthy. So you really have to think about how to flip these narratives in ways that respond, and I think Anna's absolutely right, to the current challenges of today. So I look to organizations like the Opportunity Agenda that's headed by Alan Jenkins. I look for communication specialists who can help us better understand the mood of the American public and how you frame issues. I think we do ourselves a disservice by not being more sophisticated in how we bring in information and use that to advance our broader goals. So I think that's very important as well.
Yes.
My question is beyond the DREAM Act. What do you see as the next incremental step if we've given up on the possibility of comprehensive immigration reform?
We have not given up on comprehensive. Let me say, we have not given up on comprehensive immigration reform. Let me respond to that. Secondly, I will be taken to task, I'm sure, by those who argue that I painted. Oh God, is this being live streamed? Little did I know. So I've now just slit my throat, guys. I can't go home. I want you to know I'm a refugee here in Boston. Okay, I can't go home.
You may be banished from the movement.
I'm going to be banished from the movement. I'm telling you.
Pretty quiet conversation.
All right. Okay. We have not given up on that. Okay, but I guess here's my argument. You are looking at a Senate minority leader in Mitch McConnell who has decided that a strategy of obstruction serves his interest in regaining control of the United States Senate. He is using every tool at his disposal to frustrate the achievement of legislative victories that will be seen as victories either for the Obama administration or even shared victories between Democrats and Republicans. And there is a difference between the two parties. Look, Republicans, Democrats fall in love. Republicans fall in line, okay? They respect their leadership. They pursue it. So you have people like John McCain, who was a progressive, quote, the maverick. He was a relative progressive on issues of immigration reform, as was Lindsey Graham. And those would be normally the Republicans that you would look to partner with others in the Democratic Party to achieve comprehensive reform. They have decided to sit this one out. They made it very clear that moving the DREAM Act even incrementally would generate opposition and hostility. I say going into the 112th Congress, which is the prelude to the 2012 election, you're going to have a lot of resistance. So the only way to really break that resistance is to elevate the business community's interest in getting comprehensive reform. There are two areas that we would look to. There are major corporations that have short-term needs, both for rather long-term needs, for high-tech employees and for a guaranteed workforce that's trained to do the work they need. And you also have the agricultural industry that clearly needs to have a guaranteed workforce to continue its role. Those are compelling factors. I think you get the military to speak in again about the DREAM Act. There are other issues on hand. I think the difficulty is going to be promoting legalization in the face of what may well be, and Anna is right, it's the most pressing financial crisis seen in the country since the Great Depression, but 10% unemployment may be the new normal. That may be the new normal. And when you're talking about communities of color, multiply that by 2.5, because the black community has a 25% unemployment rate if you average adult and teenage unemployment, and there are individuals who are attempting to exploit that difference for their own purposes. There's a group called the Coalition for the Future of the American Workforce, or Future American Workers, which is aiming to organize the black community as opponents of comprehensive immigration reform. Now, we have beaten that back, we have challenged it, we have pushed it. But trust me when I tell you, they're well-financed, and they are cultivating a hostility on that workforce. When you add to that the Tea Party, which is sort of looking at this issue in a somewhat nativist, through a nativist lens, concerned about the browning of America, very anxious about what this means for U.S. national character going forward, you have an explosive recipe that's going to make this a more challenging fight. So I think you pursue a dual strategy. I think you have to pursue comprehensive reform. I think we need refreshed arguments. I think we need to reinvigorate that debate with new players. But I also think you strategically pursue selected bills because you need a breakthrough. I mean, when I was asked why we accepted a compromise on the crack powder cocaine issue, I was dogged by colleagues on the left who said, my God, you've given up on this issue of getting a 1-to-1 ratio between crack and powder when you know the drugs are pharmacologically identical and you know that they have social impact. That's a problem. So, you got it.
We do have a few more. We do have some, graciously Hope has given us a few more minutes.
Great.
But I want to hear from some other people, some other folks in the audience. Did you? Yes. Yeah. Tell us who you are. Everyone knows, but tell us anyway who you are.
My name is Salvador Reza. I come from Phoenix, Arizona. Isn't it in a way that we're misreading the whole landscape? We're concentrating on U.S. Congress, and I'm not taking it even to a smaller level. Take it to Arizona. In Arizona, they passed employer sanctions. They passed all kinds of laws that are bad for business. And agribusiness especially was making a lot of noise, supposedly that they were opposed to it and all of that. But then as soon as that passed, they all fled to Mexico. They're doing all the production in Mexico. They're taking the agriculture into Mexico where they pay $3 to $4 a day instead of paying $10 an hour. And a lot of things, if it wasn't because they, in some way or another, were probably in agreement with the whole thing, they would have never let it pass. And now we, instead of like concentrating so much on the local politics, actually look at the bigger landscape, which is the corporate interests that are behind all of this. That's just my question.
I'm going to ask Anna to take that on first.
Yes. To be
Short answer.
No, I mean, we've had this discussion in the past, and really, I mean, that the way that the immigration system now works, it's broken for everybody, but those who are benefiting from it, obviously, and those are employers. I mean, employers have a steady pool of workers that are exploitable here and that they can import their problems from home. I think what Sal's referring to in part, and this is the subject for a much larger discussion, is looking at the corporate interest behind the whole criminalization, right? And that's something that hasn't been explored enough. I mean, who's really profiting from what Sheriff Arpaio is doing in Arizona, and from all of the privatization of all these detention centers that are opening up around the country? I mean, it's a huge industry right now, and there hasn't been enough probing of that industry. It's all being operated through these private interests that can all be, from what I understand, be traced back to KBR. They're all being run non-union. Workers make about minimum wage, and I mean the conditions for work in those situations are horrible. Not to mention the detention. So I think that that's a huge area that we haven't explored, and I think it's a great area for students and academics to really start looking into.
So thank you for that question, Sal, and I think for the student who asked the earlier question as well, because I think they're related. I think for us at the National Immigration Law Center, we continue to be committed to humane and broad immigration reform. But I actually do think that we have to look, the fight is not at the federal level at all, right? It's happening at multiple levels. And I actually think that there are a number of things that need to happen. At the federal level, I think in addition to the DREAM Act and ag jobs, for example, for us, and this is getting at the labor rights issue, we believe that we have to look for strategic opportunities to advance progressive policies, and one of those is the POWER Act, which is a bill that was introduced by Senator Menendez and hopefully will be introduced in the House soon, which would provide legal status for immigrant workers who've been retaliated against by their employers. Basically, it's the use of when employers use immigration status to undermine labor rights, and it's basically a right to organize bill, but it's allowing workers to have some status rather than being deported, which is normally what happens. And so finding opportunities like that at different points is important. The other piece is really the fight. The battleground is going to be at the state and local level. I mean, immigration reform is actually happening. It's just that it's not comprehensive immigration reform, right? And it's not legalization. The way that laws are being reformed is it's at the state and local level. It's when 287G is passed unanimously in Los Angeles County. It's how immigrant rights are being reformed at the state and local level, and I think that the battleground has shifted to the state legislative process, to the courts, of course, and then finally, I think it's the coalition building that Wade was referring to. The immigration enforcement, particularly the arrest, detention, and deportation of immigrants, and the use of the private prison system has really presented an amazing opportunity for coalition building between the immigrant justice community and the criminal justice community, because those same corporations that are using, the prison industrial complex, the growth of the prisons in the United States are the same ones that are operating in the immigrant detention system as well. So I think those are really the new targets.
Let me collect a couple of questions here and then get another round with the panelists. Yeah, yes.
My name's Sue Willman. I'm an attorney from the UK where I specialise in socio-economic rights for migrants. It's going back to the question about how to persuade ordinary Americans about the issues we're talking about. In Europe, one of the problems is that it's the middle classes who benefit from migration because they have people to clean their houses and work in their factories, but the front line is really amongst poorer communities and black and minority communities because they're competing for housing. It's their kids who are going to the same schools where kids don't speak English as their first language, and healthcare. And on the coalition issue, it's good to see there's quite a lot of poverty lawyers here. I wonder if there are coalitions that can be built to try and strengthen the rights of the kind of ordinary Americans so that they feel less threatened by their socioeconomic rights being taken away.
Are there other questions? Let's have a go at that then.
First, I'm on this issue. Well, first, I think I'm unfortunately going to strike a little dissenting note on the relevance of employers, having spent a lot of time in the American labor movement. I just think you have to notice that employers are not as active on whatever is left of CIR as they were 2 years ago. They're not exactly as engaged. They're not the principles there, and it tells you something about what's been happening to our economy. I do think that the era of need for mass migration is over. I really think that if sometime, some future, if we drew a graph of this era of greed that we call the United States, whatever you call it, the era of exuberance, unmet, it will match almost exactly the era of mass migration of the last 10 years. The appetite for the kind of labor that we thought was there 2 years ago, 3 years ago, just doesn't exist. And employers know that. They don't need the workers in the same way as they needed 3 years ago. I do think that that's the economic reality. The only exception to that, I think, is the agricultural sector, which is so reliant on the undocumented that, as whoever, Steve Corbett did his show, Come and Work on the Fields. I mean, that's one industry where unemployed U.S. workers would not be interested. The rest of our economy is now really subject to all kinds of challenges, assumptions about what American workers will do in the past, just because of the high rate of employment. So don't expect employers to be equal partners in it. And talking about Microsoft and all that, I mean, first of all, in my lobbying, no single real principle among employers has ever come and lobbied Congress. Really. Bill Gates is the only exception to that. He has always done it for a very specific, narrow set of people that they want. And even when they don't get enough H-1Bs, they have 6 ways around H-1Bs to get workers that they want. And they always have Vancouvers and Beijings of the world where they can send them. So depending on employers, I think, as equal partners in this, I think is going to be a very, very, I think, a much more difficult task than it was 2 years ago.
So I'm going to invite the panelists to address any of the questions and also leave us with any closing remarks or comments that you have, Wade, and then perhaps
You want
Mariana.
to come down?
Yeah.
Why don't you all go first?
Sure.
So I just want to get back to your question about how to talk to the American people, if there is such a thing as an American person, about this issue. And particularly in the context of the economics right now. I mean, we deal with this issue every day. I mean, our unions represent about 10 million people that are really a microcosm of society. We have people who are incredibly supportive of immigration reform, and we don't have to do any advocacy. There's a large swath just in the country that nothing we can say will convince them. That's the Numbers USA, the coalition that Wade was talking about. And then a large segment of the population that really is reasonable. And the challenge is to find out how do you find a message that resonates with their own experience. Working America, which is the community affiliate of the AFL-CIO, conducted a canvass in Detroit in December of 2009 in working class white neighborhoods about this issue of legalization, just legalization. And so there was a question on legalization. I don't remember what the question was right now, but it was framed around economic uncertainty. And the way that the canvassers work is that they read you the message, and then there's a clipboard. And they measure the success of the canvass based on who takes a clipboard, stage 1, stage 2, who signs a postcard to send in. So we didn't know what results we were going to get from this canvass. And it turned out that surprisingly 65% of the people took the clipboard. That was very high, much more higher than we expected. And 52% actually signed the postcard. So what that told us is that there is something about talking to people about their own economic experiences and linking legalization in a very real way to what they're living through right now. There hasn't been any funding to explore that message. There hasn't been really the will right now to explore that message. I mean, a little bit, but we can talk about that another time. So I really think that there's huge potential there to figure that out. The Tea Party has taken that message and used it in completely the wrong way. And so instead of just fighting that off, I really think there's a huge, huge potential for us to really explore that.
Thanks. So 1 minute.
Sure. Yeah.
And 1 minute wait.
We can
then
wrap
my
things
class
up.
can come.
Yes. Yeah. I mean, I think that as we've been talking about today, the need to shift strategy and to really look at what's happening on the ground. Immigrants, in addition to wanting legalization, they want to be able to survive on a daily basis. I mean, it basically comes down to really, really basic needs. Can I get up and can I go to work today? Can I take my children to school? Can I go play with a friend in the play yard. And we need to look at the issues, the policies that are impacting people's lives on a day-to-day basis and really focus on those. And that does come back down to immigration enforcement. It comes back down to the criminalization of immigrants, the 287G program, secure communities, and all of these programs, and workers' rights. And we have to start looking at a bottom-up strategy and messaging that is tailored for the state and local level. There isn't a one-size-fits-all strategy and solution to the issues affecting immigrant communities and the larger community.
Thank you, Anna. Wade?
Listen, I agree with what has been said. I guess I would temper it just slightly in the following way. I don't think there is one argument that will achieve the objectives that we've talked about here. There is no predominant argument that we can use. I think the coalition is made up of a discrete set of different interests who recognize that their self-interest is going to be affected in a positive way by what we achieve. We're not going to be able to sell this based on sort of high-minded principles of American democracy. We're not going to be able to sell it on the basis that it's the right thing to do. We're going to have to show that there is interest. There's a self-interest motivation that moves things forward. So you're seeing, for example, a wonderful new coalition with the labor movement and civil rights groups and others around trying to have labor law enforcement that, because it is one way of helping to eliminate the incentive of employers to exploit the undocumented. You have an op-ed that Janet Murguia of the National Council of La Raza and I have written together urging a boycott of the All-Star Game next year in Arizona. And we're going after not just the All-Star Game, and we're building on the litigation victories that you guys have helped to achieve in the courts. But we're going after the All-Star Game because it's a huge venue that helps to send a signal to the state. But it's not just the All-Star Game. Arizona is now 50% of the preseason games that, take place preparation for the regular season. We're going to try to go after the economic value that Arizona gains from all of these global players from the Caribbean and from Latino countries who fill baseball. I mean, you've got to figure out ways to put pressure on the system, and that has to often be done collaterally, and it has to be done in coalition.
So there are 75 young people outside who are dying to hear something about civil procedure right now. So, but before they rush in, I want to thank all of the panelists. This was absolutely fabulous.